We're here in cause number 1932623, and we have had some discussions in the back that I think we need to put on the record with regard to the case and where we are. We have, first of all, sir, you're Dalvius Williams, and Mr. Williams is here with Mr. Rojas. Mr. Smith is here on behalf of the state. There is a second amended motion to revoke unadjudicated probation. So because of the new allegation, I'm not going to accept the plea agreement of the cap of 4 years because there's a new. So I will allow, if Mr. Williams wants to withdraw his pleas of true to 1, 2, and 3, and go through those again and get pleas today on those, and then we can go forward with what we have today. And then if I feel like there needs to, it's my understanding, Mr. Smith, for today, you have witnesses with regard to proving up count 4 only. Is that correct?
That's correct.
So what we can do today, depending on what those pleas are, either way, we'll go forward with what we have because there's witnesses here. And then if I feel like
This case hits differently from the very start. The judge refuses the plea deal right away, and you can already tell something serious is brewing. When a court pulls back on a negotiated sentence, it usually means they're seeing a pattern or a danger they can't ignore.
Okay. So just to go back, count 1, Mr. Williams alleges that you violated your probation by failing to report to the probation department October 25th and December 15th of 2022. You had previously pled true that was true. And do you want to continue to plead true to that count? Okay. And then count 2 alleges that you're behind in your court assessed fees as of January 4th of 2023 in the amount of $3,638. You previously pled true to that count. And do you want to continue with your plea of true to count 2? Count 3, which was in added in the first amended motion, alleges that you committed the offense of evading arrest or detention July 14th of 2024. You had previously pled true to that count, and do you want to change your plea of true in that count?
When Williams tries to take back his true plea for evading arrest, you get the sense he's backpedaling, maybe realizing how deep he's in. But it's also a signal that he's not ready to take responsibility, and that's going to haunt him.
Do you understand that? Okay. Mr. Rojas, you've gone over all of that with him, correct? And it's also my understanding that y'all had, even in the back, Mr. Williams' mom in the back to go through everything, what his options were, and all of that this morning. Is that correct as well?
Correct.
Okay. What if any offers? I want to make sure Mr. Williams, on the record, rejects anything that's been offered.
We had offered 4 years in this case, Judge.
Did that include an offer in the injury to a child?
Actually, I offered 4 years in both cases to run concurrently.
Okay.
If he went today.
Okay.
He said no. And I told him that if he didn't do that, if we go to trial on the new one, I would move to stack that case on whatever he gets in this case in the 4s.
This right here is the moment of truth. The judge lays it all out, exactly what's at stake. Williams could have taken 4 years and been done, but instead, he gambles everything. And when the state says they'll stack charges if he goes to trial, that's serious. That's how someone ends up doing 12, not 4.
Okay. And so your options are today, if you wanted to go forward with a plea in both of your cases, plea of true in that motion to revoke for a 4-year sentence, plea of guilty in the new injury to a child case for a 4-year sentence, with the agreement that those sentences would run at the same time. You don't have to do that. We've got witnesses here. We'll go forward with the hearing. Just want to make sure you understand what your options are today, you won't have after today, and what your consequences could be if you go to trial and if we go forward. And nobody's trying to talk you into anything. I just want to make sure you understand it all. Does that make sense? So you understand everything that's been offered and what you could do today and kind of where we're about to go, right?
Then we get the full picture, and it's dark. He's got a prior for criminally negligent homicide, a guilty plea on injury to a child, multiple arrests. Probation's revoked again and again. This isn't a one-off mistake. This is a dangerous pattern.
Then the felony criminal history I show is a criminally negligent homicide from 2017 where probation was given in 2018. That probation was revoked in 2020. Looks like that probation was revoked based on, and looking back on all of this, I'm not real sure other than what we were all thinking, but it looks like on January 10th of 2020, the probation was revoked on the criminally negligent homicide. There was a new offense of injury to a child that he appears to have pled guilty on and received a 12-month state jail sentence. There was another new offense from January of 2019, an attempt to take an officer's weapon, also same disposition date of January 10th of 2020 for the 12 months in the state jail. And then there was this possession case that we're here from that same date. So it looks like he took some time.
This is the gut punch. The judge doesn't just sentence him. She scolds him like a mother protecting a child. You shouldn't be around any children. You can't even care for your own. That line hit me. It's not just about breaking the law. It's about breaking trust over and over again.
I understand everyone's position. I think with regard to, there'd be different evidence, I would think, and probably more potentially at a trial. I'm not required to look at all that. And obviously the level of the burden is different. So count 4 is true. Mr. Rojas, you may proceed with argument.
If the court is inclined to keep him on probation without ISF, we ask you to do that. If that's not going to be possible, Judge, we ask the court to consider something in the range for the possession case, 2 to 4 years.
All right. Thank you, Mr. Rojas.
Judge,
Mr. Smith?
I believe his criminal history shows fairly convincingly that he is unable to successfully complete probation. If he's a probation officer, I don't believe it's their desire to keep him on probation with this type of charge pending, especially in light of the fact that he's already been convicted of injury to a child within the last few years. That tends to me to show more than just a pattern, it's a habit. The fact that he doesn't respect authority is shown by the jail incident reports. Feel like he needs to be revoked in this particular case, and we're asking for no less than 5 years, somewhere between 5 and 10 years as punishment in this particular possession.
8 years. That's the number. But for these kids, especially the 2-year-old mentioned, the damage is deeper than years can measure. You don't bounce back from repeated abuse. And the court made it clear, this man had too many chances.
You're 30 years old? You just turned 31. So I appreciate that you have support here and people here to support you, but your behavior to me tells me that you shouldn't be around any children, much less your own. Whatever is happening with you when you're getting angry at these children with what you're doing, because it's the same. This appears to be the exact same type of incident that you pled guilty for a few years ago when I put you on the probation for the possession. I mean, it's ridiculous. You and Ashley both don't need to be around any children. Don't need to be having more children. You can't take care of your own children, and you're disciplining them by doing this. And I don't think there's any reason for anybody to believe that no one said these are scratches. That's not what the doctor said. If there are, they're adjacent to these other marks on the back of this 2-year-old. Going to find, again, that you entered your plea of true to counts 1 and 2 freely and voluntarily. Find those counts true. Find count 4 true. Find sufficient evidence at this time to find you guilty of possession of a controlled substance. I'm going to sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections.